Welcome to the Explainer. Today we're going to break down a really crucial topic for your law exams, valid acceptance. You know, getting this right is pretty much the key to nailing those big 15-mark questions on the Indian Contract Act.
So, let's kick things off with a big question. When does a simple yes, actually become a legally binding contract? The answer is a little more complex than you might think, and it's really the bedrock of contract law.
So to get to the bottom of that, we've got to go back to square one. What is acceptance, legally speaking? And what's the magic ingredient that makes an agreement actually, stick?
So, right off the bat, you need to get this. Acceptance is way more than just saying yes. It's that final, absolute, no-turning-back agreement to an offer. This is what creates something lawyers love to call consensus ad idem, basically a true meeting of the minds. It's the spark, the thing that ignites a simple proposal and forges it into a real, binding promise.
And of course, the law gives us the exact wording, and listen up, this is a must quote for your exams. Section 2B of the Indian Contract Act lays it all out, but pay close attention to that last part. A proposal, when accepted, becomes a promise. See, that's not just a change in terminology, it's a massive legal shift with very real consequences.
Okay, so we've got our definition, but just saying, I accept, isn't the whole story. For that acceptance to actually hold up in court, it has to play by some very specific, very strict rules. Let's dig into what those are.
All right, rule number 1, and this comes straight from Section 7, is a big one. Your acceptance has to be an exact mirror of the offer. It's got to be absolute and unqualified. So, if someone offers to sell you their car for 5 lakh, and you come back with, sure, I'll take it for 4.5 lakh, guess what? You haven't accepted anything. Nope. You've just killed the original offer and put a new one on the table. That's a counteroffer.
Next up, and this is so important, you can't just think, I accept, in your head and poof, there's a contract. That's not how it works. The law demands some kind of external action. You have to actually tell the person who made the offer that you accept. And this is a really important safeguard, right? It stops people from getting trapped in contracts they didn't even know existed.
And finally, how you communicate your acceptance really matters. If the offer says you must reply by email, and you send a WhatsApp message, sorry, that's not a valid acceptance. You've got to follow the prescribed method. Now, if the offer doesn't specify how, then sure, any reasonable way will do, but the responsibility is on you, the acceptor, to make sure your message actually gets through.
So this really lays out the whole journey, step by step. It all starts with a proposal. Then, that proposal gets an assent, an agreement that's absolute, unqualified, and properly communicated. That action, the acceptance, is the magic moment. It transforms the proposal into a promise that's legally binding. It's a really clear logical flow.
Okay, so theory is one thing, but how does all this play out in the real world? Let's take a look at a couple of landmark cases that really hammered out what acceptance means in practice.
Okay, first up, the classic case, Feldhaus v. Bentley. So you've got this uncle who tells his nephew, basically, if I don't hear from you, I'll assume that horse is mine. The court came back with a very clear, nope, you can't just force a contract on someone by making their silence the acceptance. The law needs a clear, outward act of agreement.
Now, Powell v. Lee adds another crucial piece to the puzzle. In this case, a school board decided to hire a guy named Powell, but he didn't hear it from the board officially. Instead, one of the board members acting on his own told him the news. The court said, no contract. Why? Because the acceptance has to be communicated by someone with the actual authority to do so. A bit of gossip from a third party just doesn't cut it.
So if we put these two cases together, you get a really clear picture. Feldhaus is all about how you accept. It can't be through silence, it has to be an action. And Powell is about who communicates that acceptance. It has to be the person making the offer or their authorized agent. They're two sides of the same coin, and both are absolutely fundamental.
Okay, exam time is coming. Let's boil all of this down into some quick, easy-to-remember notes. This is the stuff you want fresh in your mind right before you walk into that exam hall. When you're writing your answers, listen up. These are the 2 sections you have to cite. Use Section 2B when you're defining acceptance. Then bring in Section 7 to talk about the rules, that it has to be absolute and follow the right method. Nailing these citations is the bedrock of a top-tier answer.
Seriously, think of this slide as your blueprint for the perfect answer. You start with the definition from Section 2B, then you build on it with Section 7, showing that the acceptance must be absolute. You hammer home the point that it must be communicated. Then you bring in the big guns, Feldhaus and Powell, as your case law to prove that silence isn't enough and the communication has to be authorized. Wrap it up by mentioning the prescribed mode. Follow that roadmap and you're well on your way to getting top marks.
And to wrap things up,
Here's a little something to chew on. How do these rules, born in the 19th century, apply to our world of instant communication? Imagine you're on a phone call. You say, "I accept," and the line drops right at that second. Is there a contract? Who's responsible for making sure the message was heard? These are the kinds of questions courts are still wrestling with in the digital age. It just goes to show the law is always evolving. Thanks for joining us on The Explainer.